Hello, hello, hello. This is attorney Mike Gravlin coming to you from Chicago. As usual, we got a little Sunday night hangout. I'd had people asking me about the Karen Flamethrower. Her name is Sarah, actually, I believe. Sarah Pike. Anyway, a video just came across my my feed, and it was good. And this happens. I sort of fell into this rabbit hole. I did this with Drunk Attorney in Court and a bunch of whatever. You guys don't know them, but so I'm not in order. I'm not in chronological order. It's just the order in which I find them. But this is pretty good because she's of course having this custody battle. She lost her children. It appears for all the world by her own actions. To me, anyway, based on what I've seen. And we've seen a few of those. She's, of course, trying to get rid of all the judges and that sort of thing. But we're back. This one has a little more substance to it, sort of. You kind of see where she's going. You kind of see the argument that she wants to make, but doesn't know how to. And then before we even get to that, I've got a nice little appetizer that was sent to me by, let me see here. Oh, come on now. By Amanda on IG. Thank you very much. A few other people mentioned it, but Amanda actually sent me a thing with the starting point. That's actually helpful because I don't have 6 hours to just go roving through calls. But it's our old friend Judge Gauthier up north, and he's maintaining the courtroom decorum up there. It's pretty good stuff. Let's get it started here, shall we?
All right, we're back on the record in the 53rd Circuit Court. Let's see. Here. All right, we're calling the case of People v. Brogan, file 21-6098. Counsel, you want to place your appearances on the record, please?
Melissa Goodrich, Blaine County Prosecutor.
Good afternoon, Your Honor. James Mikowski, P6215, appearing on behalf of William Grogan, who's also appearing by Zoom.
All right, Mr. Mikowski, is your email address jjm@mikowskilegal.com?
Your Honor.
How often do you check your email?
Fairly often.
A week ago, my staff emailed you that this hearing was being changed in person for you and your client. The reason is I didn't catch it at the time, but afterwards I was advised and went back and reviewed. While we were in court on Zoom on the record, you, sir, smoked a cigar. You have forfeited your right to appear by Zoom in my courtroom from here on out. So I need you physically present in my courtroom for the hearing. I will not conduct a hearing over Zoom with you, Mr. Mikowski. I'm not going to do a show cause or anything, but you've lost Zoom privileges. So what I can do, if you didn't get that message, I'm not sure why, but I will have you come back on July 26th at 1:20 in the afternoon in person for you and your client.
This is typical. A lot of people ask this question, why don't judges do this? They'll do it to attorneys all day. They have a very high standard for attorneys. They'll do all sorts of stuff to attorneys. But when you see these pro se litigants, they feel sorry for them. And they think, oh, they don't know any better and this and that. And they don't want to appear mean. They will stick it to a licensed attorney all day long. It's just very typical. He just wants to clean it up. He doesn't want people smoking cigars and doing those sorts of things. He wants his appearances to go smoothly. And I understand where he's coming from. The other thing that's odd about this, and it was before my time, but I mean, they used to smoke cigars in court. I mean, they used to have ashtrays in Cook County and probably everywhere else. So I still see an occasional attorney with a cigar in court, not lit. I've actually seen that in my career. So this doesn't seem like the largest transgression to me. I mean, you have people showing up taking a shower during the call, and this guy has a cigar on. He probably shouldn't, but he has a cigar on Zoom, whatever. But I like Judge Gauthier, and he decided that's his line. That's what he's going to do.
Anything further, Mr. Mikowski?
You.
One moment, Your Honor.
Well, I mean, I'm going to give you the benefit of the doubt that you didn't get it, which is why I'm just adjourning it. If you got it and chose not to come, that'd be an entirely different problem. So I'm going to assume you didn't get it. Okay, no problem there.
Your Honor, if I did get it, I apologize. I missed the in-person aspect of it.
That is just full of honesty right there. He said, I'm going to assume you didn't get it. He knows he got it. And the attorney did get it, but he literally didn't know he had to show up live. He didn't see that part of the email. He's not looking for that. If he's like me, he gets thousands of emails a day. He's just like, okay, there it is. What's the next date? You're not scouring through for like, did I get dinged for smoking a cigar last time I was in court? You're not thinking about that stuff.
Okay. All right. So 2 weeks from today at 1:20 in the afternoon, I'll see you and Mr. Grogan in my courtroom physically present. Thank you.
Thank you, Your Honor.
Good day, Mr. Grogan.
Okay, so here we are for the main event. There's our hero, bottom right, Sarah Pike Levy or whatever. I don't know if I'm pronouncing that correctly. She's got blue hair today. She's got blue hair. That's a good indicator right there. I'm not saying all women with blue hair are filled with misandry, but it's a strong indicator. It really is.
All right, let's go ahead and get started. Ms. Leva, you have your 5 motions to strike.
Yes, ma'am. And I just want to confirm really quick that it's showing. Oh, it is showing up. Thank you. I appreciate you letting me start. First of all, I want to make sure everyone did receive a copy of the amended filing. Ms. Borum had mentioned in one of her motions that she didn't like how they were 5 separate. They were not intended to be. And I just want to apologize to the court for that. I'm not an attorney, cannot afford an attorney, nor can I find an attorney. And all of those motions to strike should have been in one motion. So for the benefit of Ms. Borum, I did amend it, put together as one motion, and instead of the affidavit, I also attached exhibits.
Ms. Leva, I'm going to ask you to slow down for me so we can get you accurate on the record.
Oh, yes, sir.
Thank you, the Wanda Life.
I also submitted exhibits for the courts as well as Ms. Borum. Every exhibit is a court document, and almost everyone has been ratified by a judge, so there is no danger of hearsay or anything else of the like.
Thank you.
All right, let me get your amended motion. I don't have your amended motion in front of me. Let me get it just a minute, please.
Yes, ma'am.
Solace, would you get that off the printer for me, please? Yeah.
And Your Honor, I don't believe I received any exhibits.
Your Honor, the exhibits were attached to the motion when they were submitted to the courts. They were accepted by the courts, and I even clicked on them and verified that they were correctly attached and were made available to Ms. Borum. Or we could use my affidavit instead, whatever you would prefer, Ms. Borum.
That's judged
I
to you.
have filed what looks like Exhibit A, and it includes.
Yeah, if you go down, it has all the exhibits attached to the file. And again, they've been on court record since, most of them since 2015 and a couple of them since 2018. 2 of the exhibits are filings that Ms. Borum, not Ms. Borum, but Ms. Newell submitted herself. And so the party should already have full knowledge considering they wrote it and submitted it. There's nothing new in the exhibits. They're all available on our case files.
All right. Go ahead, Ms. Leva.
Thank you, ma'am. So we're here today to discuss the motion for enforcement, which was filed August 21st, 2018. It was motion for enforcement of possession or access in order to appear and maintain 2 violations. And the other we'll start with that one, and contain 2 violations. Neither of these violations were a violation of my irrevocable mediated settlement, and neither one should have even been able to be submitted and accepted. I want to start with Exhibit 1 on page 1. It clearly states the mediated settlement agreement is not revocable. And we have Nicholas Leyva and Sarah Leyva's signature on November 11th, 2015. Above it states the parties understand and agree that this agreement is binding on all parties and not subject to revocation, as set out in 6.602 and 15.3.0071D of Texas Family Code and Civil Practice and Remedies Code, Texas Property Code, and other applicable statutes.
I'm going to
Oh,
ask.
I'm sorry. I thought I was speaking slowly, sir. I was trying to read slowly.
Okay, well, I want to try to get you down accurate here. So,
I appreciate. I'll go even slower, sir. I apologize.
That's okay. I'm just trying to get you down accurate.
Okay, I'm trying to respect everyone's time as well. Apologize.
Oh, that's rich. I'm trying to respect everyone's time. All of this is a complete waste of time on a meritless motion, but okay.
Okay. As I said, it goes by those Texas codes and other applicable statutes. It is underlined as well as in all capital letters that each party specifically stipulates and agrees that she has entered into this agreement freely and voluntarily. This agreement is not subject to revocation and is enforceable as a contract. And then if you switch to the next page, technically it is the fourth page in the file. It shows on January 29, 2016, the court heard the case, and at the very end, it is signed and ratified by a judge on that day. Now, if we go, so I just wanted to clearly show that. Now, if we go to motion for enforcement, which was the very first thing that was filed, it was filed on August 21st, 2018. I also want to point out that
What is, I mean, I still, this is my second time through. I still don't understand this. Yeah, I think this is a 2021 hearing, and we're bringing up a motion from 2018. You know, it's not good.
it was also signed by Matthew Reed, judge presiding, on the exact same day, August 22nd, 2018.
It's a
I had
spectacular
no
idea,
chance to
Mortimer.
respond. I was given no copies. They simply signed enforcement without any evidentiary basis. On the page four of this exhibit, it states violation 1. On April 22nd, 2016, Sarah E. Leyva removed the children from Birdsville ISD and changed the primary residence of
Slow down.
Oh, sorry. On April 22nd, 2016, Sarah E. Leyva removed the children from Birdsville ISD and changed the primary residence of the children by moving to the state of Virginia. You go, and again, I also went ahead and on all my exhibits, I put points of reference so that everyone could prepare before this hearing, just to make it easier. So if you go to the geographical area for primary residence on our mediated settlement, I believe it is on page 8. These orders are so big. All right. It clearly states, it is further ordered that the geographic restriction on the residence of the children shall be lifted if at any time Sarah E. Leyva wishes to remove the children from Birdsville ISD for the purpose of changing the primary residence of the children. And this was intentionally included in our mediated settlement because we had lived in Texas for less than 6 months when Nicholas filed for divorce. The children were born in Virginia, their schools were in Virginia, their family was in Virginia. And so this was part of our agreement, as well as Nicholas being able to hide all of his finances, as well as his military benefits. I just want you to understand what he was getting out of this. I was able to go home.
It's right there.
The relevance of this testimony as it predates the last order in this case. And
Your Honor, that order again is void. There is, and if you would let me finish, Ms. Borum, you have absolutely no specific facts in which to add.
Oh, the gall. She interrupts her to say, would you let me finish? She makes an appropriate objection at the right time. She allows her long periods of time to talk. Sarah never does that for her throughout the hearing.
Nor is what you're saying is lawful. Any order that is built on fraud is void.
Your Honor, I'd like to renew my objection to this line of testimony as predating the last order.
When was the last order, Ms. Borum?
I believe that there was a trial held in front of Judge Catterton, a modification of custody on February 22nd of 19. That order was signed by the court on March 29th of 19.
Again, it was procured in fraud.
And
It was
then
what?
the controlling order was a order for supervised access through family court services. And that was signed by Judge Navarez on January 30th of 2020.
All right, I'll have to sustain the objection, Ms. Leyva. Please bring your argument up to the relevant time periods, please.
Okay, so I want to just make sure I
I
understand.
just do,
So
Yeti.
you are going to not allow me to move forward on my
Thank you.
motion. You understand there is explicit and extrinsic and intrinsic fraud in the procurement of this new order, which makes it void. And additionally, you understand that we had an irrevocable mediated settlement.
This new order, as she likes to call it, is the current order that was in place that was entered by a judge and has not been vacated. That's the method of getting rid of that order. That the last order, or whatever chronologically, those orders are in effect until they're not. You're just saying, I wish they weren't. That's great, but they are.
Nicholas signed of his own volition, which he has breached on multiple occasions. But again, you are choosing to obtain her objection and be completely biased and ignore the letter of the law.
There's example A. We got a guy who has to make personal appearances because he smoked a cigar on Zoom. What she just did, I'd be in cuffs for if I said that. You know, just call the judge biased and throw accusations around. There would be cuffs on me from a bailiff within 30 seconds. Me or anybody else practicing in Cook County, Illinois.
The letter of the law states any order maintained through fraud, third-degree perjury. And if you will let me continue, I can show how this is third-degree perjury, but I don't think Ms. Warren wants me to show that right now.
Your Honor, I would also that it seems facts not in evidence, as there's been no testimony put forward or elements met for the claim of fraud.
Objection, no testimony is needed. Again, it's all in the court records. The evidence of perjury is clear. One perjurious statement is more than enough to vacate the final order, which has already been proven in the last 5 minutes.
No, it hasn't.
All right, overruled. Ms. Borum, your objection is sustained. Ms. Leyva, go ahead and bring your arguments up to the relevant time period, which would be from February 22nd, 2019 to the present, please.
Your Honor, again, that is against federal law, against Texas statutes, against my constitutional rights, intentional breach of contract, intentional breach of parental rights. I have done absolutely nothing wrong. I have been upward and honest. I have never broken our mediated settlement. Nicholas Leyva, Borum, and Newell committed third-degree perjury, and right now you are committing misprision of felony.
Okay, Annie is asking very nicely for you to like, subscribe, and hit the bell notification. And if you ignore Annie, you do realize that that is considered capital felony treason.
So if we are not going to move forward on this motion, and everyone is in agreement that they want to basically ignore my basic human rights, as well as my children's basic human rights, as well as the Constitution of the United States and Texas statutes, you may as well move forward with Ms. Forums.
All right, if you do not want to pursue
Your Honor, I do. As I stated, there is fraud in procurement of a final order where they committed third-degree perjury. However, you refuse to let me move forward because the new order is void.
All right. You do not want to pursue your motion to strike?
I absolutely do. Okay, fine. We'll stick with strike and we will ignore the void. So, as I stated, that first violation needs to be struck because it is in direct violation of our mediated settlement. So she, again, committed third-degree perjury on a motion. And then we have the we have the second violation, On July 1st, 2016, Sarah E. Leyva failed to surrender minor children to Nicholas Leyva at her residence. Again, third-degree perjury or at least intentional deception in accordance with our mediated settlement. Nick's time began at June 15th, 2000.
Amen, Mayor Wrench,
June
McNown.
15th for residents that were more than 100 miles apart. Not only did he not show up, he didn't contact me, but I cannot provide witness testimony. So we will stick with that. The truth is, it is not a violation because he was supposed to be there on June 15th to pick them up. And he did not do so.
Oh, there's a prequel. By the way, this is number 3. So I did actually make a Flamethrower playlist. It's qualified now. It's my accidental rabbit hole playlist here.
All right, respond, Ms. Borum.
Yes, Tonor. Once again, would object to the testimony based on the fact that it predates the trial that was held on February 22nd, 2019, which modified not only the MSA, but the underlying agreed final decree of divorce, which reflected the MSA. I would be happy to take testimony on this matter. However, to simply short circuit to my argument.
Agreed, Joe.
I would ask that the relief requested by Ms. Leyva's motion to strike be denied and that they be deemed as frivolous pleadings. As the court is, of course, aware, special exceptions and motions to strike, which I assume is what she is requesting today, should be filed with an answer shortly thereafter in a case. And in a non-jury trial, which, excuse me, which was what was heard in front of Judge Catterton on February 22nd of 2019, these motions
I see what you did there, Charles. You throw hearsay in at the end. Well played.
must be brought before the judgment is signed. That judgment was signed on March 29th, 2019. Under the Texas Rules of Civil Procedure number 90, defects in pleadings which are not brought before the judgment is signed shall be deemed as being waived.
Thank you.
However, Ms. Leyva brought these motions almost 2 years after the fact. Her testimony has circled around actually actions that took place as early as 2016, and in her motion specifically, she objects to actions that took place in 2018, and this was significantly before the final trial that was held before Judge Catterton, in which testimony was taken and a final judgment was entered once again on March 29th of 2019. And so for those reasons, while I'd be happy to take testimony from Ms. Leyva, I would ask that her 5 motions, or rather the amended motion that was filed yesterday, be denied and that attorney's fees be awarded.
I'm glad we cleared the hurdle today.
All right, Mr. Passmore, do you have any argument on this?
No, Your Honor.
All right. Anything further, Ms. Leyva?
Absolutely. First of all, what she says is untrue and insufficient. By law, anytime fraud is found, there is absolutely no statutory limit to fraud. There's no statutory limit to third-degree perjury. Additionally, at that time that she is speaking, I had 2 attorneys. One attorney removed himself from the case after the jurisdiction hearing, which again was blatantly biased, which I do provide records of. And I also hired Lindsay Newell after the final order, and I had requested her to adjust the perjury. However, instead she canceled my appeal and took wage for disservice. I found out later that she had gone to college with Miss Lindsay Newell and they were personal friends and operated together in order to have my children removed. However,
also that you have absolutely no grounds for appeal, and that's why it stopped. It really has nothing to do with any of this side nonsense you're talking about.
We'll move forward without any further testimony. I will stick straight with the facts as well as the paperwork, just because testimony is unnecessary.
Yes, that's
so
it.
As I just previously stated, and we went over, motion for enforcement of possession or access of order, both violations were intentional third-degree perjury and need to be struck from the record because they hold no bearing or merit in regards to our mediated settlement. The second one that she filed was petition to modify parent-child relationship, which she also filed on August 22nd. And this is also another issue. Oh, no, August 21st. So she filed motion for enforcement and petition to modify parent-child relationship also on August 21st of 2018, despite our mediated settlements. And again, this was ratified by a judge in the same day without any reference to our mediated settlement, the law, or any evidence. So she stated in the modification that I removed the children from the state of Texas and that was a violation of our mediated settlement. However, in her request to change parent-child relationship in the modification of prior order, she requested that the order include, on page 3 of 6, include a geographic restriction because there was none. She requested geographic restriction of Tarrant County, Texas, and counties contiguous to Tarrant County, Texas.
Honor, Mayor.
You may.
Thank you. First and foremost, I would object to the continued testimony with allegations of perjury and fraud, not to mention child trafficking, not to mention the allegations that the court and the attorneys in this case are involved in a cartel. There has not been any admissible evidence presented to support claims, on top of which I would renew my argument that all of the issues that are being complained of by Ms. Leyva today predated the last order. She is in fact correct that a mediated settlement agreement was signed in that it was reduced to an agreed final decree of divorce on January 29th of 2016. That order was not revoked. In fact, it was properly modified by the modification trial that was heard by Judge Catterton on February 22nd of 2019. As of course the court knows, then that became the controlling order. Within that order, Judge Catterton granted my client the exclusive right to determine the primary residence of the children within Tarrant County. Shortly after that trial, Ms. Leyva exercised her first period of possession of the children, and during that period of possession, I suppose she determined that she would not return the children, which she did not, for 10 months. My client...
Okay, so they had an order that the children were supposed to be raised in this county in Texas, and she took them to Virginia. And they had every opportunity to fight about that, and she probably told the judge she wanted to take them to Virginia. And in that hearing, they said, no, these kids are going to stay here for whatever reason. And she said, well, then I'll just take them anyway. And that's the crux of this whole problem. I mean, I'm only seeing bits and pieces, not all of it, but that tells the story right there.
Filed a subsequent enforcement, which is not being addressed by Ms. Leyva today, and which I believe we are still attempting to serve her with, which we were talking about at the last hearing, which I will happily address during the presentation of my motions.
All right.
However, the also the allegations that the children have been kidnapped and she's been denied any access to them is also not supported by any evidence. In fact, the order signed by Judge Navarez did grant her visitation. She simply has not exercised it. I believe these motions were filed frivolously.
Ouch. So she's saying that the kids are kidnapped from her, and the attorney sticks it to her there. She's so mellow about it that you almost miss it. But she said, no. She actually was granted visitation, but she never does it. That just looks horrible. It's not a matter of law, but it just does not make her look good. That's the truth of the matter.
With the intent to harass my client, who's had to spend an inordinate amount of money to defend these hundreds of pages of motions that have been filed by Ms. Leyva. So once again, just in relation to the motions filed by Ms. Leyva and not the motions filed by myself, I would ask that the court deny them on the basis that they violate Rule 90 of the Texas Rules of Civil Procedure, and she has...
Meanwhile, she's down there just rolling her eyes and throwing a hissy fit, while this attorney, Catherine Borum, is making all the sense in the world and is doing it very dispassionately, just saying, well, here's the situation. It's hard to watch sometimes.
Has waived her right to...
Objection, Your Honor. Can Ms. Borum go over this when we are ready to address those issues? She has repeated these same things twice in a row now instead of just simply objecting. She needs to object as I present, not be a witness.
All right. I think I've heard enough on these motions.
Your Honor, this is inappropriate. For one thing, she just lied again. She said I had
It's not for you to determine what's appropriate.
them after the final order, which I did because they never left the state of Virginia. However, I did not abscond with them. And that order was also fraudulent. Catterton stated that he thinks that we need to change custody without any statute or regulation backing it. He simply said that we had struggled with communication and that he hoped.
He has jurisdiction. I'm assuming it's a he. I think because I think that's what she referred to him as. They had a hearing. He has jurisdiction to make these determinations. He determined that that's the way the custody should go, and he entered an order. You have not vacated the order. That order's in effect. You don't get to just say, I don't think it's right, I'm going to violate it. That's not how it works.
That by changing the jurisdiction and residency of my children and giving Nicholas Leyva basically, making him custodian, again, without finding any fault with me or giving any statute backing his decision, said, this is how he put it. He said, I think, Nick, I better give Nicholas full custody in order to promote better communication. Since then, I have had no updates, no phone calls, no pictures, no response from Nicholas Leyva at all. I haven't even been able to verify that.
Motion to strike.
No, but I would like to continue with my motions to strike, ma'am. All right, so as we all know, the motion for enforcement, again, there were 2 perjurious violations that were never violations, which is against my constitutional rights. Petition to modify child-parent relationship supports this because she requests that the prior order be modified to include geographic restriction of Tarrant County, even though she claims it was a restriction already in her original filing.
Yep, she thinks she's the judge and a party.
Your Honor, as multiple motions have been filed,
Ms. Gorham.
I ask that Ms. Leyva specifically identify the dates of the filings that she's referring to.
All right, Ms. Morton.
Absolutely. I actually started with that because that's part of the problem of why it's so fishy. The motion for enforcement was filed 08/21/2018 and then was signed by Judge Matthew Reek on the exact same day. And then again, petition to modify parent-child relationship was also filed on August 21st, 2018. Again, without any chance to respond, without having any copies. And in my opinion, this exemplifies vexatious litigation to the extreme.
Yeah, it turns out your opinion doesn't matter.
And additionally, an intentionally trying to defraud the courts, because they did. They defrauded the courts. They have built an entire case on defrauding the courts, and not a single one of any of their documents have ever had specific facts or evidence to back any of their claims. And I do want you to consider my prayer. Now that you are aware that they committed perjury, deceived the courts, defrauded the courts, and have continued to keep my children under a fraudulent...
We're not aware of that. We're aware that you're making that allegation. You've made that allegation 4,000 times. No one's taken it seriously because you haven't proved it. That's what we're aware of.
Final order that didn't even have any sufficient validity to back the order. As of today's date, Joshua and Samuel Leyva, who were Virginia state residents, have been held hostage for 492 days. They have been prevented from all contact with myself. I am their natural biological mother, their lawful custodian. The level of legal abuse, torture, intentional deprivation of children's rights, intentional deprivation of parental rights, third-degree perjury, financial fraud, not to mention breach of contract, shows a planned, decisive, and intentional infliction of torture inflicted upon Sarah Leyva and her Virginia state minor children, Joshua and Samuel Leyva. I also request all reference statements and admissions to be struck from the record that have been proven to be falsified. And I do request, now that the courts are fully aware of fraud and procurement, that there be at least an emergency order to remove the children from Nicholas Leyva's home and for them to be returned to me. I am okay without the money, even though it has been stolen from me. And I have had to pay a significant amount of money, not to mention lost extreme amounts of job income, travel costs, garnished child support payments from wages and IRS tax fraud, and not to mention all the missed child support payments, which again, I am more than happy to weigh. I simply...
Why does she preface everything she's mentioning with "not to mention"? It's minor, but it's really annoying.
Request that my children be removed immediately from Nicholas in light of the fraud in procurement of final order, and everything else I'm happy to let go of.
All right. Any further thoughts, Ms. Borum?
No, I would simply renew my previous arguments, and I would also point out that Ms. Leiva's continued allegation simply that she says there was fraud or fraud in the procurement without producing any evidence to support that, and also without having those motions before the court today. I would submit that
Objection. I would like to know how I have not proved fraud. I have just presented two incredibly important pieces of evidence that...
You haven't presented any evidence. You've made allegations. That's what you've done. You have a fundamental misunderstanding of law and how it works.
Are on court record that do show third-degree perjury and fraud upon the courts. And no matter what Ms. Borum is saying, she can't change a lie into a fact.
All right.
Just because you state it does not make it true. There was fraud in procurement, and I have been victimized over and over and over. My children have been erased from their mother intentionally to inflict torture, which is established as psychological, mental, or physical pain, which, believe me, after 495 days, you state you have a 9-year-old, you would understand. This is insane.
All right, Ms. Leiva, please let Ms. Borum finish her argument. Thank you.
Thank you, Your Honor. So in addition to renewing my previous arguments as my statutory basis as to why the relief should be denied in this case, I would also like to reiterate that there hasn't been any evidence submitted other than Ms. Leiva's personal testimony that she believes that, based on her interpretation of the law, that fraud has been committed. However, as I've said, the mediated settlement agreement and the attendant decree were properly modified before Judge Catterton and entered by the court on March 29th of 2019.
That's actually an interesting question. I always have this with all soft sets. I don't think she believes anything she's saying. I think she just is seeking attention. I don't think she thinks she has any chance of prevailing, because in her heart she knows that she doesn't have the merits on her side, but she loves the attention. I have no idea. I'm not a psychologist. That's just my gut feeling.
And so, once again, I would ask that these motions be denied and that attorney's fees be awarded as to her motions specifically. Thank you.
All right.
Objection to attorney fees. I've already filed as an indigent. I do not have any money. And again, as I stated before, they clearly committed fraud in procurement of the order. Regardless of whether, it doesn't matter if you acknowledge that or not, it's just truth. And I am simply attempting to see.
Well, you see, it does matter if she acknowledges it, because she's the judge. So you can't just make things true by proclamation. It's not how it works.
My children, these are not meant to harass or harm Nicholas in any way, which is why I was so willing just to remove all the other requirements. I don't want any money back. I do not want to hurt him in any way. I simply want our mediated settlement to be held up, and I would like to hold my children again.
All right.
You don't act like it, and when you have an opportunity to do so, namely in the visitation that's set forth in the order, you don't take advantage of it. So I'm having a hard time believing that.
Borum, did you want to put on testimony of attorney's fees?
Yes, Your Honor, I would please. Would you like me to do as to her motions first and then to my motions and my presentation?
Yes, first.
All right.
All right.
My name is Catherine Borum, State Bar number 2404.
Raise your right hand.
Sorry.
Do you swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
This is weird. I don't know why they're testifying. I've never really done this, but she just does a petition for fees. She knows she doesn't have any money. She knows she's not going to collect it. She's trying to get her to stop. That's the idea behind this petition for fees. She is absolutely filing these things. All these motions have been brought up numerous times, and she's failed, and she can't prove it. So all she's doing is harassing, and your ability to pay should not affect whether or not the judge assesses the fees.
Yes, ma'am.
All right, thank you.
Thank you. Your Honor, my name is Catherine Borum, and my state bar number.
Excuse me, have we finished with mine? Because I'd like to give a closing statement.
We finished with your presentation. She's putting on her attorney's fees as in response to your.
I mean, all she's done is argument so far. This judge is so. I would just say no. You know, that's it. But you know, she just bends over backwards for her.
Well, I have one more thing that does need to be specified on court record before we move on to hers. I also wanted to point out the petitioner's supporting affidavit, which was attached to the petition to modify. This is not, again, a legal document. On page 2 of 2, as you can see, it is not notarized in any way, shape, or form. Actually, when I looked up the name of this notary, I found that she was social media friends with Nicholas Leyva. I don't know if she assisted him or if he just borrowed her stamp. It doesn't matter. I'm not going to try to imagine how it happened. I simply want to state that it.
I'm going to sit here and throw a bunch of innuendo and then say I'm not going to try to imagine how it happened. Oh, stupid and transparent.
Is not a notarized affidavit and is not a legal document to back the petition to modify child support either.
Anything further, Ms. Leyva?
No, ma'am. Go ahead and have her start. Excuse me, ma'am. Are you going to give a ruling on my motions before we hear Ms. Forums? Considering my
Oh, she sure is. She sure is.
mine were put forth in January, and you contain, again, excessive extrinsic and intrinsic fraud, which I just showed to the court today. Should there be a ruling on that?
I'm trying to get to that part where I can rule, but first I have to hear from Ms. Borum. All right,
Even
Ms.
though her
Borum.
motion was, Your Honor, I want to speak on her motion before she moves forward. I have some.
No, we're not there
questions
yet.
for-
Excuse
It
me.
is a
we're not there
procedural
yet.
question, ma'am. It is a procedural question. It has nothing to do with her actual filing. In her filing, she filed it Friday at 3:30 p.m. And again, this is what makes it vexatious. She filed it at 3:30 p.m. on a Friday. It was accepted and served by the courts at 4:59 p.m. at the time of closing of the courts. And then somehow Kate Daniels sent me a copy of the order for hearing about 5:30. And an order of hearing from the courts. And I would like to know procedurally, Ms. Judith Wells, how you were able to read a 7-page motion, order a hearing for it, all within 20 to 30 minutes after the courts were closed.
I can tell you could read a 7-page motion in 1 minute, especially if you're a judge and you've seen it 4,000 times. The counsel for the father here is asking for attorney's fees. You don't need to read that. This isn't difficult. We'll set it down and we'll have a discussion on it that day. I can do it in 3 seconds. So can this judge.
Additionally, I would like to point out that a copy of this order was never provided to me. So I don't know how, again, I mean.
This is outrageous. In here is the nub of a decent thing. She's saying, I don't have sufficient notice. Just say that. We'll set it over for hearing another day. A judge, that ultimately happens. That isn't a big deal, but this isn't some grand conspiracy, and she thinks she doesn't have an order. No order was entered. Somebody spindled a motion, as we say in Cook County, or you set a motion for a date. That just happens through the clerk's office. The judge isn't involved. There's no conspiracy. When you file a motion, you send it to the court and you ask for a date. They give a date. There's no order entered. You just set for a date, and then you go there before the judge, like they are right now, and then an order is entered.
Was this order already signed and just waiting for her to file the motion? Was it just signed because the motion was unread? There's just not enough time for this to have occurred, and it's completely inappropriate that it occurred after closing on Friday.
No, it's not.
On a holiday weekend, and had an order before I had any opportunity in order to respond to it and stop a hearing. This is a frivolous filing. in direct relation to try to stop the truth and the evidence from
No, this is a request for attorney's fees in response to a frivolous filing.
coming out about fraud in procurement. Additionally, I did go over her entire filing with someone who's been a lawyer for over 40 years, and there's literally nothing specific in it. She makes very general arguments. She does not provide any evidence. She does not provide any specific examples, and I wanted to bring that to the attention before she tries to make specific examples without providing, again, any opportunity to respond before order or any opportunity to review it before litigating against her in a court of law, which is my right. I have a right to know what her arguments are going to be before they are made.
You have a right to a copy of the motion, which she provided you. If you want more than that, if you want a briefing schedule, that's what you're kind of flailing around about. You don't get it as a matter. I mean, if you want a briefing schedule, you ask the judge for that. Say, I want time to respond to this. That happens every day. But you know nothing about the law, so you can't spit that out. So you go into this crazy conspiracy mode, and it makes me pull out my dramatic hamster. That's what happens.
Your Honor.
Yes, ma'am.
First and foremost, that my motion for special exceptions, motion to compel and for sanctions, and motion requesting that Ms. Leyva be deemed to be a vexatious litigant, or in the alternative, a request for determination that her filings were frivolous, was in fact filed on Friday. Ms. Leyva has made the allegation that I participated in an ex parte communication with the court by virtue of filing this motion.
Ex parte, they get to this here. She doesn't understand what that means. Ex parte means would be like if Catherine Borum called up the judge and said, hey, what are we going to do? Yeah, that's an ex parte communication. Filing a motion with the clerk's office that gets to the judge, which is the whole freaking point of it, is not an ex parte communication. That motion will be sent to the parties of record along with the judge. That is the only way to communicate under this circumstance. It's proper, and it's the way to do it. And she thinks it's ex parte. I mean, it's laughable.
Of course.
Objection is not in filing a motion. It's in receiving an order for hearing, despite me not receiving.
There's no order. It gets set by the clerk's office. No judge enters an order.
Any order for hearing again after the closing of courts. How is that possible if it's not ex parte communication?
Is the court, of course, aware, a motion is a request for relief. It is not an order by the court granting that relief.
No, the order was for a
The attorney does a really nice job. I would be too cranky to do that, but she actually pulls it back and explains it to this numbskull.
hearing, which again I never received, which I was sent by Kate Daniels, who obviously received it through ex parte communication, which is against the law. And therefore, your hearing, this motion needs a continuance and should be heard at a further time after you have been able to, I have been able to respond appropriately, number one, and number
This almost does make me miss the 36th District Court.
two, prepare for it. And number three, I'm included in the communication from the courts, and there is no ex parte communication involved.
Your Honor, as the court is aware, I'm not required to marshal my evidence prior to the hearing. Presentation of evidence to support the relief I'm requesting is the purpose of us being here.
Form, you're breaking up really bad on this end.
Oh, no.
So let's go ahead and start back where you were.
Here, am I coming through now?
You're coming through now.
Okay. I'm not sure where I broke up, so I'll just back up a little bit. As the court is of course aware, the motion that was filed was not an order. It was simply a request for relief, and I am not required to marshal my evidence within a motion. In fact, that's the purpose of us being here today, is to have said evidence presented to the court, with Ms. Leyva having the opportunity to respond to such evidence so that a determination can be made on the relief that I'm requesting.
This is so awkward because she's saying this to the judge, who clearly knows all of this. I mean, she's not communicating to the judge. She's hoping Dummy picks it up, but she's not paying attention. The whole thing is comical. It really is.
It was filed and set last Friday. meeting the requirements under the code that she have 3 days notice of the motions that were filed and set by me today.
Objection, I believe that, again, this requires a 3 business
she's
day
pretty good.
notice, and because it was a 3-day Memorial Weekend, this isn't sufficient.
All right, Ms. Borum.
Your Honor, my motion was submitted. It was submitted on Friday. It was then, Ms. Leyva received a copy of it. It was properly filed. It was properly set for hearing to be heard today. And as the court is aware, there's...
Objection, it was again not properly set for hearing because the order was sent through ex parte communications, and I have again not been provided a copy of the order from the courts to this date.
She was provided a copy of the notice of hearing by my office. I believe Ms. Leyva might be a little confused what an ex
I agree.
parte...
So her office had interactions with the courts in order that, in a way that they were able to receive a court order after hours on a business day, a
believe she
holiday
is.
weekend. They were able to receive this order without any communication with myself whatsoever, and this is considered appropriate by the courts.
On
I
Zoom
file
on the
motions
record, you, sir,
every-
smoked a cigar.
Oh, I file motions every day where I don't communicate with opposing counsel. Every day.
Ms. Leyva's motions that have been filed before the court, I would represent that reasonable and necessary attorney's fees for this motion are approximately...
That to
Right.
happen. It was to the court, specifically to the judge requesting relief, which has been in there since January
Sorry.
of this
I moved
year,
it back.
which again has had no response, and I've had to wait 6 months for a hearing while my children have remained in Texas with no contact with their mother. Additionally, I have already submitted my affidavit of indigency. I don't have any money, cannot provide any money, and I have not signed a contract with Ms. Borum. I have not promised her any money. And if the court sanction this, they are again willingly...
You don't need a contract. These are sanctions imposed by the judge. Again, just on every level, fundamental misunderstanding. But she is confident.
assisting Ms. Borum and Ms. Newell and continuing to defraud the courts. And as a judge, I assume that's not your intention and that you don't want that to happen. You want to uphold the letter of the law. And I know there has been a lot of issues with this case and a lot of deception. And I hope that at this point that you can now see through that.
All right, the motions to strike are denied. The court finds that Mr. Leyva is entitled to attorney's fees in the amount of $2,500, which Ms. Leyva is ordered to pay to Mr. Leyva.
That's interesting you say that. I actually had a conversation with Michael McDonald. I was thinking about having him on. Tell me what you guys think about that idea in the chat. Alex put me in touch with him. We had an interesting conversation. That may or may not happen in the future, but let me know what you guys think of it.
Directly at his residence address by June 30th of 2021 at 4 p.m. That'll be the order of the court.
Okay, I'll see you guys in appeal. Have a nice day.
All right, wait a minute.
I will give Judge Wells this. She knew she was ruling against her, so I think that's part of why she's so she knows she's hitting her with a hammer. So she's just kind of letting her go throughout the day. I think she should have clamped down much earlier. In substance, the judge is very good. She gets there and she's made a conscious decision to let her tire herself out. But I wouldn't have the patience for that. And then, of course, right afterwards, look at this expression. I just happened to randomly do that. But look at this expression. She's like all excited. She knows she's going to lose. And then she wanted to get her little line in that she's going to appeal as if the judge is worried about that. I mean, you know, the judge is going to be affirmed on appeal if she ever manages to file one, which I doubt. But if she does, the judge will be affirmed. But even let's say she was wrong and the judge got overturned. So what? I mean, it doesn't really change her life much, you know?
We still have Ms. Borum's motions.
We're going to hear her motion even though she put it in again on Friday on a holiday weekend after the courts, 1 minute before the courts closed, and I still have not received the order. Are we really going to move forward on a motion where I have not received any order from the courts for a hearing?
Well, Ms. Leyva, I was going to ask you, were you wanting a motion for continuance on that?
I did. I responded with a motion of continuance.
All right. I do think it's been a minimal amount of time for the allegations that have been made for notice, so I'm going to grant the continuance on that.
I mean, I could see that coming all day long. In the 45 minutes this woman spoke, she had one good point. She's like, hey, I don't know if I had sufficient notice to hear opposing counsel's motion today. That is a fair thing to say. Everything else was complete and utter garbage. And the judge, despite the fact that she couldn't spit that out in a rational way, the judge found it for her and said, fine, well, let's set this over and we'll have the hearing on the sanctions another day. That makes a lot of sense.
Ms. Forum and Ms. Leyva, if you will, after this hearing, get with Ms. Lopez and get another hearing set on that motion, and I will grant her motion for continuance.
Thank you.
All right. Thank you, Your Honor.
Thank you.
Thank you, Judge.
Well, there you have it. Flamethrower number 3. I think that's in the middle of the two. I have one where she's in front of a male judge, and then I have another one where she's in front of, this is Judge Wells, I believe. Well, who I kind of like, but I think is too permissive. And not because she's stupid, she's made that choice. It's hard to watch sometimes. Let's face it. That's why I have content though, because that's what's that's what made all this sort of entertaining, is that the judge was a little permissive. And my gut feeling on that is the judge was permissive because she knew she was going to deny her motion. And they tend to do that. They tend to let you go, especially like with a pro se. And they don't really care about attorneys' feelings. Attorneys don't have feelings. We're robots. We're void of feelings, and the judges know it. But pro ses, they don't understand law and they get emotional. So the judges just think, I can either like lay the hammer on them from the get, or I can let them tire themselves out and then just rule against them. I mean, or rule on their behalf if they ever have any merit to their argument, but they just rarely do. It's not to be rude. It's just so. As ultimately the judge has to call balls and strikes on law, and this woman has not successfully brought the right motion and given evidence for the claims that she's making. So as a matter of law, she's got to lose. The judge simply wouldn't have a factual basis to do it. What she doesn't appreciate, she's asking a judge to overturn a modification order entered by another judge. She would need a good basis to do that. You just don't willy-nilly say, "Oh, I'll just come in here and upset everything that everybody else has decided." You can do it if you have a factual basis, a record. Somebody on a properly filed motion, and they elicited testimony, and they made those arguments. And if someone came in here, laid a foundation, and said, "Really, I can show that the prior order was only entered because the person perjured themselves," that's a good argument to make. That's the one she theoretically wants to make. The problem is she doesn't have any facts or evidence to do that. As a theoretical matter, that would make sense, but she thinks she can do it by fiat. Just I said so, and it's just, I don't know. It's just not how our system works. So, that's a lot of fun. I don't know if there's more to the Flamethrower series or not. I don't know, but I had been getting, I've been getting comments. Some of these videos I think are just meant to be. I've been getting comments like, "Hey, I'd like some follow up." This really isn't follow up in the sense that it goes back, but it's sort of fills it in. But I've been getting comments about this, and then all of a sudden this just comes across my feed, and I thought, all right, it's fate. We got to do Flamethrower number 3. That's the way it is. All right, thank you all for coming out. That turned into a very fun Saturday night. I appreciate it, and I will see you all soon.